So I wanted to talk about the purposes of California's APA, our Administrative Procedure Act, and like its federal counterpart, the state APA provides the formal procedures by which the executive branch agencies and departments are required to conduct their quasi-legislative or rulemaking activities. So what's the purpose of the APA according to the courts of the state of California? There are essentially two main purposes of the APA. The first is to give notice to persons affected by a regulation, and the second is to give them a voice in its creation. The court said this in Mission Guadalupanas of the Holy Spirit versus Royale, and also Morning Start Company versus the State Board of Equalization, a 2006 decision by the California Supreme Court. Other courts have stated these two purposes similarly. For example, one appeals court described a major purpose of the state APA is to provide a procedure for persons or entities affected by a regulation to be heard on the merits in its creation and to have notice of that law's requirements so that interested parties in the regulated community can conform their conduct accordingly. This was the Court of Appeal in 2008 in Morales versus California Department of Corrections and Rehabilitation. Now, some courts in the state have specified a third purpose of the APA. For example, one appellate court described a purpose of the APA as advancing meaningful public participation in the adoption of administrative regulations by state agencies and creating an administrative record assuring effective judicial review. This was the Court of Appeal in Baskin versus Hughes Realty in 2018, as well as Poet LLC versus the State Air Resources Board in 2013. In addition to these main purposes, there were purposes stated by the legislature, such as the APA was created because the legislature perceived there existed too many regulations, imposing greater than necessary burdens on the state, and particularly upon small businesses. As a result, a formal review process of proposed regulations was in order. The Court of Appeal said this in 2007 in California Forestry Association versus California Fish and Game Commission. In addition, some state agencies were viewed as adopting regulations that didn't provide notice or an opportunity to be heard, which are called underground regulations because they're adopted without following the formal procedures and requirements of the APA. As a result, one Court of Appeals described the APA as being designed in part to prevent the use by administrative agencies of underground regulations, and it's the courts, not the administrative agencies, that enforce this prohibition against so-called underground regulations. The Court of Appeals said this in 2003 in California Advocates for Nursing Home Reform versus Bonta. As part of the California APA, the legislature has enacted a number of findings and declarations, and these are contained in the first two sections of the APA statutes, found in California Government Code section 11340. And that code section provides 7 different provisions, including some findings and declarations. For example, the language of many regulations is frequently unclear and unnecessarily complex, and the language is often confusing to the persons who must comply with the regulations. Also, substantial time and public funds have been spent in adopting regulations. The imposition of prescriptive standards upon private persons and entities through regulations could reasonably be expected to produce the same result has placed an unnecessary burden on California citizens. There also exists no central office in state government with the power and duty to review regulations. And the complexity and lack of clarity in many regulations put small businesses, which do not have the resources to hire experts to assist them, at a distinct disadvantage. In addition, in Government Code Section 11340.1, there is a provision that states the legislature declares that it is in the public interest to establish an office of administrative law, which shall be charged with the orderly review of adopted regulations. And it's also the intent of the legislature that the California Code of Regulations are made available on the internet by the Office of Administrative Law. So there are a number of legislative findings and declarations in statute regarding the necessity of the APA in the state of California, as well as clear statements in the APA statutes and by the courts regarding the myriad purposes of the state APA.